Hello, Estate Planning Mom here, Krista Hermance. So thank you so much for joining me. It is Wednesday, 6 p.m., and I am here for our weekly estate planning questions and answers. So if you are just joining us and you've never been on before, please post your comments and questions that you have, any estate planning questions you want me to answer into the comments so that I can make sure to try and get to those for you. I do have some questions that people have sent in over the last week that I'm going to get to first. But if you do join us, please make sure to post your comments or questions in the comment section. Okay, as always, if you have any questions at all and you don't feel comfortable posting them in the comments or you want to reach out on something else, please always feel free to email me. The email address is info@hermancelaw.com. And as always, you can go to our website at www.hermancelaw.com. And then lastly, you can also text our office or call, of course, 805-518-9633 with any questions or if you want to set up an appointment. Okay, so first question. How are you handling appointments with COVID-19 and social distancing? This is a really great question. So we have lots of stuff that we put into place to make sure that our clients are safe, and we're doing as much as we can to make sure that we have all of these safety protocols in place. So one of the biggest things that's very different, especially since the pandemic started, is we moved to only doing virtual meetings with clients for our initial appointment. So generally that is a family planning assessment, or if it's for a probate or trust administration matter, we are doing all of those now through Zoom. And if you're not comfortable with Zoom, we also do it over the telephone. And we've actually been virtual with the ability to see clients virtually for the last year. So it was a very easy shift for us just to just do all of our appointments that way because we did have that familiarity and those systems in place. So right now we are not meeting with clients in person for that initial meeting. And it seems to be working out well. Clients are really enjoying the ability to just be able to stay home, not have to drive anywhere, to be able to meet with us to, one, do the assessment to find out, what type of plan they need in place, and then two, to design their plan. And then everything we do from there has to do with, following up with them, and we do all of that through our client portal, which is the secure client portal we do online, where we message each other back and forth, we share documents, and we're able to do all of that, obviously, virtually. And then the other piece, which is the signing. So when we do estate planning, we generally have a signing ceremony where we go through and we sign all of your estate planning documents, whether it's witnessing or notarizing those documents. So in California, we do not have the ability to do a virtual signings or virtual notaries. California just hasn't enacted that the statute to be able to allow the ability to do that. Some states have, especially with the pandemic. There's a lot of states that have gone into play that are now allowing virtual signings, but California is not one of those. We still need to sign all of our documents in person when it comes to at least notarization and then witnessing. So we, what we're doing is if we have a client that is local to one of our offices, either Ventura, Westlake Village, or Santa Clarita, we do an in-person signing. It's very different than it used to be, though. It used to be we sit around a table, it takes about a half an hour to an hour, we go through everything, and it's kind of a very intimate setting. Now we have designated spots where clients will sit at a table and the notary and the witness will stand or sit generally more than 6 feet away. It's a very kind of smaller set that we have you sign. We don't have you sign the whole binder. We just have you actually go through the signature pages to make it really easy to know which ones to sign. So since we're not hovering over you to be able to show you where. Everybody's wearing masks. Our team also generally wears gloves just in preparation and stuff for the binder. And then you'll go through and sign that. In preparation for that, I am doing virtual walkthroughs of your estate planning binder, as well as my team, the other attorneys, where we do it virtually, where we send you a video going through all of your documents so that you know, and then can ask any questions or anything. We are Also from a virtual perspective, when it comes to clients that aren't local, we are sending all of our documents to clients with instructions on how to get these things signed virtually with a notary and witnesses. And then they're just mailing back the documents to us, and then we are sending all of their documents once we get those signature pages back to them shortly thereafter. So that is our process. We are tweaking it as we need to make it better for clients, or as different things come into play. But right now we're just being very cautious with obviously being close to people, making sure that we're wearing masks, having hand sanitizer, wiping down everything before clients, and then before clients come, and then after clients are there, just to make sure that we are doing our part while still trying to get clients to be able to put plans in place to protect their family and get their wishes legally documented. So if you have any questions about the process, if you're concerned, please feel free to reach out to us. I'm always available to talk through any issues that you have. Our team is very knowledgeable on the stuff that's going on, as well as making sure that you feel comfortable, because that's really what's important to us, is making sure that if you do have those concerns, that we can address those. Okay, if you are just joining us, please make sure to post your questions in the comment section. Again, always feel free to email us, info@hermanslaw.com, or call or text our office, 805-518-9633. So thank you again for joining me today. I am here every Wednesday at 6 p.m. answering your estate planning questions. So let's go to the next question that we have. Okay, if my parents pass away, doesn't everything just go to me and my siblings? So this, I think, is a really kind of big misconception I see amongst people, that they just think that, oh, if my parents pass away, I get everything, or me and my kid, or me and my siblings get to share it. And it really depends on what type of planning your parents have in place. If your parents have no plan at all, and let's say they own property, right? They have real property, they own a house, and something were to happen and both of your parents passed away. Well, that property doesn't just automatically go to you and your siblings. It has to go through probate court. And again, we're in California, so and everything that I'm talking about is California, but it's good general advice for anybody where you're located. So if the property is owned by your parents individually and they own it in their name, the property can't just pass to you. It has to go through, in California, this probate process. And probate process is when the court oversees that when somebody passes away, how their stuff is distributed to their heirs or beneficiaries. If you have a will, so if your parents had a will that said how they wanted their stuff distributed, then that would be looked at through the probate court. In the probate court, it would be distributed through the probate court according to their wishes. But it doesn't avoid probate court just because they have a will. And I think a lot of people don't really understand that. Just because you have a will doesn't say, well, my house is going to go to my kids. It has to go through probate court to get to the kids. And, it doesn't avoid probate court. So probate court in California is generally things people, if they understand that they can, try to avoid. Probate court is very expensive. It costs a lot of money, and that's set by statute. That's not even something that's just, the attorney says how much it's going to cost. It's set by statute in California. So there's a lot of money that goes into having to put an estate through probate court. The probate court process in California is very long, so it can take anywhere from 1 to 2 years. That means that the assets that you have that have to go through probate court, the family might not have access to that. So if you have a house that's going through probate court, that mortgage might still need to get paid, right? If there's a mortgage on it, which means the beneficiaries may have to continue to pay that mortgage while it goes through the probate process to essentially be sold in the end. But there's all these kind of things that need to be taken into consideration. So long story short, if there is no planning in place, or if there is just a will, that stuff is going to have to go through probate. The way to avoid that is by doing a trust. And so a trust is a legal agreement in which you give certain instructions to be carried out after you pass away. You name what's called a trustee and then successor trustee to manage your estate. While you are alive, generally you are the trustee, and then only if something happens to you does your successor trustee kick in. So the way that we work with clients in designing a plan to avoid probate is by creating a trust where their house and their assets go into the name of their trust, so that if something happens to them, rather than their house be in their name individually and have to go through the probate process, is it's in the name of their trust. So then at their passing, the house then is just distributed according to the terms of the trust. It avoids that probate process. So a lot of times I hear clients that, they go through the process, because we focus a lot on families with minor children and trying to make sure that they have plans in place to make sure their kids are protected. And so when we start this process, a lot of times it'll get into discussions about their parents, and they'll say, well, my parents, they don't have any planning in place, or, my parents are very standoffish and they don't really want to talk to me about it. And this is the time to make sure that you understand what your parents have, because if something happens to them, who's going to be the one who's dealing with it? And so it's important for you to know what type of planning documents your parents have. And I understand that some parents can be that they don't want to talk about it, or it's personal information they don't want to get into. But it's really important, I feel, to push to at least get the information as to what they have, because I have found in the past, in having these discussions with my clients who then talk to their parents about it, is the parents will have what they think is the correct plan in place, but it actually isn't. And so maybe they have a will, but a will isn't going to avoid probate, and they might not understand that. And so that's why it's important to kind of push a little bit more to figure out what documents they have, not just take their word for it, they have planning documents in place, but what type of planning documents do they have in place, so that you understand that, because if you're the one who's going to be dealing with it when your parents pass away, it's important that you know, so that if you know, you can actually then talk to your parents to understand, to make sure that they understand what will happen with the planning documents that they have, because they might not be aware of what they actually need. And I've seen this happen a lot recently as people have been passing away, that the documents that they think are the planning documents that they need aren't actually the planning documents. And one example is, I've had people that have come to me and say, oh, my parents had a will. And then they give me the document, and it's not actually a will, it's a living will, which in California is what we call an advanced healthcare directive. It's basically, while you are alive, how do you want your healthcare decisions made if you're unable to make those? So that has nothing to do with probate. It has nothing to do with your stuff. That has to do with health issues. And so that's what a living will is. And so it's really important to make sure that you have these discussions. I know they're hard, but have these discussions with family and make sure that they have the proper planning documents in place, and that you understand where they are, or what they are, and where they are located. I see that often, where people have to go searching through parents' homes, looking through paperwork, trying to figure out what they have, because they don't know where any of the documents are located. And that's why it's so important to make sure that you have an understanding of where they are located, and if they're locked up, how to get access to them. Have these discussions now. It's important. I know it's hard and people don't want to talk about it, but it needs to be talked about. Okay. If you're just joining me, thank you so much for joining me. Make sure to post your questions in the comments if you have any. And as always, please make sure to email us, info@hermanslaw.com, if you have any questions. You can also text or call us, 805-518-9633. And again, if you don't want to share your questions on here, hi, thanks for joining, then you can always email us, and I can get to them either offline or in our next one, which is going to be next Wednesday at 6 p.m. So make sure to log in then and watch. Okay, last question I have is, I really want to get a trust but can't afford it. Do you have payment options? Yes, absolutely. We want to make sure that you can get a plan in place to protect your family. And I understand that cost, especially right now with everything going on, can be a concern. So we do actually have payment plan options available. The way that the payment plans work is we take the cost of the estate plan and we will divide that into 6 payments. And you will make those 6 payments, with the first one to start, and then over the course of the next 5 months, make an automatic payment that we have set up through our system, where you will make that payment. And then at the end of the 6 months, you will 10 days after that last payment is made, we will get all of your documents signed and your estate plan put in place. And so over the course of those 6 months, you're making payments, we're doing the drafting, we're communicating with you, we're getting everything set up. And then once all of the payments are made, you can get everything signed. And so that is one option that we do have for clients, that if you can't make it all the payments at once, you know, in one lump sum at the beginning to start, then we do have those payments available to you. Okay, that is all I have from questions for today. Thank you so much, everyone, for joining me. And again, tune in next week on Wednesday at 6 p.m. Where I will answer your estate planning questions live. And again, please feel free to send us a message. You can go online to our website for more information, hermanslaw.com, or send us an email, info@hermanslaw.com. Thanks again, and have a wonderful day.